This is 230094 LT Kirkridge Park Cooperative versus Linnell Pruitt, Rosalind Gale Morgan, and all other occupants. May I have your appearances, please?
Good afternoon, Your Honor. Julie Croda, P39367, on behalf of the plaintiff, Kirkridge Park Cooperative.
Thank you. Your name?
Linnell Pruitt.
Miss Pruitt, is Rosalind Gale Morgan here?
No, she's deceased. She
Oh.
hasn't been on the lease for 4 or 5 years.
I'm so sorry. It's in the caption with her listed as the second defendant. Today is the day and time set for the trial in this matter. Is the plaintiff ready to proceed?
Yes, Your Honor.
Defendant ready to proceed? You may be seated, ma'am. Any opening statement?
Just very brief, Your Honor. Your Honor, this is a case for a termination of a tenancy and an occupancy. Everything is based upon contract. We have an occupancy agreement and multiple documents. Those documents in an exhibit pack. I have one for the court. I have also presented one to Ms. Pruitt, asking her if she would stipulate that would speed things along. And then in addition to that, Your Honor, we have 5 witnesses here to establish that there was a breach of contract of the occupancy agreement, bylaws, rules, and regulation, and then a subsequent last chance agreement based upon behavioral conduct, that all of that was broken, and that's why we are here today seeking termination of the occupancy.
Thank
May I
you.
present these?
Yes, ma'am. Ms. Pruitt, do you wish to give an opening statement at this time, or would you like to reserve that?
Yes, Your Honor.
Opening statement is just the summary of what you intend to show as your defense to the claim.
I intend to show you text messages. My daughter has a video of the property manager trying to fight a tenant in front of other tenants, and where I stated that this is who she is, and the text messages from the property manager states that they have video of me opening statement that they cannot have anything that's not true of that nature.
Thank you. Ms. Pruitt, plaintiff's attorney has passed up to the court a packet of proposed exhibits in this matter. Have you received those documents as well?
Yes, Your Honor.
And she's indicated on the record that she's asked for your stipulation or agreement to admit these documents. Have you given that agreement?
Yes, Your Honor.
Is that accurate, ma'am?
As of now, yes.
Okay.
She just didn't answer me yet, but that's fine.
That's fine. That being the case, the documents that have been passed up to the court have exhibit stickers on them, but they have not been enumerated. The court will receive them in their entirety.
And Your Honor, I guess I can either number or letter your preference as we refer to them.
Thank you. That's fine. Your first witness, ma'am.
Your Honor, I would like to call Stacy Klaba.
Ma'am, come up to this middle podium for me, please. State your first and last name and then spell them both.
Stacy Clayback. It's Stacy. Last name is K-L-A-B as a boy, A-K.
Ms. Clayback, raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you much. Come up here, please. Sit in the black chair that's closest to me. My secretary is recording your testimony this afternoon. If she can't hear you, I'll ask you to either pull that closer or raise your voice, okay?
Yes, ma'am.
Thank you. Your witness, ma'am.
Good afternoon, Ms. Clayback. What is your position and your relation to the plaintiff, Kirkridge Park Cooperative?
I'm the Director of Operations for Clearview Property Management. Kirkridge Park Cooperative is our client. We are contracted to manage and facilitate the employees and the property.
And how long have you been in this position?
26 years.
And in this particular matter, are you familiar with both Kirkridge and the defendant in this matter, Ms. Linnell Pruitt?
More familiar with the property, Kirkridge, and then the file itself for Ms. Pruitt.
And you are familiar that she lives there at Kirkridge under an occupancy agreement, correct?
Yes,
Where is Kirkridge located?
it's in Romulus, or Belleville, I guess that's the street. But it's on Kirkridge Drive. It is a cooperative community.
So Ms. Pruitt is there pursuant to an occupancy agreement, correct?
Yes,
I'm going to hand you what we have as stipulated exhibit. Your Honor, this will be exhibit 1, the occupancy agreement. I think it might be the third one in your file. If you remove the-
Yes, ma'am.
Ms. Clayback, can you tell us what this document is?
this is the original occupancy agreement. Upon purchasing into the membership of the cooperative, you agree to the terms and conditions under an occupancy agreement, the bylaws, and the rules and regs.
And who is it signed by?
It looks like a J. Smith was for the management at the time, and then Ms. Pruitt, and it looks like there's a second signature below it. Last name Nelson, maybe?
So the defendant in this matter has signed the occupancy agreement?
Yes,
And what was the date that that was done? Was that in 2015?
correct.
And one of the things we discussed was that it's both Ms. Pruitt, and there was another name on it, Ms. Morgan, but we are now updated that she has no longer there.
Correct.
She passed away. And what unit was Ms. Pruitt occupying? Was
It's
it unit
unit
114?
114, located at 7483 Kirkridge Street.
And is this property HUD subsidized?
No, it has a 236 HUD agreement. So the regulatory agreement allows for the property to obtain a low-interest loan mortgage and able to establish an easier budget in order for them to, operate. And in return, they have to keep their rates below a certain level that are published each year.
So how are the carrying charges, what some people would commonly call rent, if this was an apartment, if this is co-op, how are the carrying charges determined?
They're determined by the Department of HUD.
And what was Ms. Pruitt's carrying charge per month?
In 2015, it looks as if she had $625 per month.
And that probably would have changed up until the present,
Correct.
but we're not here on a non-payment. She has been paying. We're here on another issue, correct?
That is correct.
And I would like to direct you to Article 6 of that agreement.
All right.
It should be an article for peaceable possession of the property.
Correct.
Can you summarize for the court what that means?
It means that each member agrees to conduct themselves in a way that promotes harmony, peace, and quiet enjoyment of everyone. That
And
help?
yes, that's part of our contract, correct?
Correct.
I'm now going to hand you what will be marked as Exhibit 2, and this will be the bylaw. Are you familiar with that document?
Yes, I am.
And what is it?
The bylaws are established at the time that the cooperative was put into a corporation. This enabled them to sell the memberships through the HUD program, and every person has got 1% piece of the pie.
And when people move into this cooperative, they are handed the bylaws and expected to know what their obligations are, correct?
Yes, and they're also available in the office at any time.
So in this document, there's one particular area I'd like you to look at, and that is Section 9 regarding termination.
I'm sorry, I'm trying to find it. Yes, I have it.
So is this the section that notifies people that their rights to occupy the co-op and their rights to be a shareholder could be terminated and how that occurs?
Yes, it does outline the expectation of the membership and what could deem a termination of it.
And is that what we're here doing today? Attempting to terminate her rights to her shares in this unit, which therefore give her a right to occupy?
Yes,
Okay, and I want to back up 1 second with you, Ms. Clayback. As compared to a normal apartment complex where somebody rents and has a right to occupy, This is different, correct?
Yes, it is.
And also with a condominium, where you actually purchase a unit, and then you are a co-owner with the condo. This is still different, correct?
Yes.
So here with a cooperative, what exactly is the difference?
In a cooperative, you are buying into a corporation. There's no real estate per se. You are given a certificate of occupancy that allows you the right to occupy the unit that is assigned to that certificate. And in this case, I think it was 114.
So basically, what Ms. Pruitt owns is shares of a corporation. And
Correct.
what those shares give her is the right to be in, like you said, unit 114, but sometimes that changes, but the right to occupy a
Yes.
part of this cooperative, of this corporation. And also, is there equity involved in this? Did she have to pay to come into this cooperation?
Yes, yes. And because it's HUD, it's relatively a lower amount.
So she had to put some money down before she was allowed to come in. She had to invest,
Yes, ma'am.
and then she had to pay her monthly carrying charges.
Correct.
Anything else?
They pay their own utilities at the property, and any the interior, they're allowed to do, or they can request. But in this case, because of the HUD piece, there are certain things that are given as part of that membership. Like if there was floors that are redone, or maybe cabinets, maybe they're doing an upgrade to the bathrooms, that type of thing that you wouldn't traditionally see with like a condo.
I'd also like to give you one more document. This is going to be marked as Exhibit 3. This is titled the Kirkridge Park Cooperative Rules and Regulations. Are you familiar with this document?
Yes.
And what do you recognize it to be?
This is the rules and regulations that set forth by the board of directors for the property, and it can only be amended by the board.
And people get this when they move in, occupants get a
Yes.
copy of this when they move in, and they're expected to conduct themselves accordingly.
Yes,
Now, from the time that Ms. Pruitt moved in, has there been an occasion when she was brought into court prior to today?
I would not have firsthand knowledge of that.
I will address that later. Are you aware that she was still staying in the unit under what is called a last chance agreement?
Yes,
I'm going to present to you, this will be Exhibit 4, entitled Conditional Occupancy Agreement Addendum for Probation. Now, are you aware of this document?
yes, I am.
And what do you know that to be?
When the property board of directors receives complaints or concerns on a member, if it cannot be an easy fix, they normally will bring them in to a private meeting. And if they are able to come up with some terms or guidelines, they will create this probational period. And it's an agreement between the board of directors and the member for a certain period of time.
So you are aware that there was a last chance agreement entered into between Kirkridge and Ms. Pruitt?
Yes,
And this was done in June of 2021?
correct.
What were the terms of that agreement? How long was it to last for? Was this a 2-year probationary period?
Yes, it was 2 years.
And I'd like you to address numbers 2 and 3 in this agreement. What
All
was
right.
the main concern of Kirkridge in entering into this agreement with Ms. Pruitt?
This was for the household. All members of the household were to have no act committed that would, jeopardize the enjoyment, the peaceful enjoyment of any other members. They would not approach other members. There would be no complaints received into the office or to the board in their box during this time period.
And what about number 3?
Number 3 outlines that there'd be no acts committed, again, by the household members that would create a nuisance or interfere with the health, safety of others. And this is also to include the staff, management, contractors, board of directors, anyone that they would be encountered on the property.
And is that signed by Ms. Pruitt?
Yes.
At some time after this agreement was signed, did Kirkridge, with the understanding of the management, file a termination proceeding alleging a breach of this agreement?
Yes.
I'm going to hand you what is marked as exhibits 5 and 6. Exhibit 5 would be the notice to quit. Exhibit 6 is the actual summons and complaint this time.
Thank you.
Ms. Klebeck, are you personally aware of any of the allegations in this litigation that have resulted in us being here today?
Yes.
What are you aware of?
I believe the way that this came about was some complaints had been submitted again in regards to behavior and outbursts. So the board of directors had to have us reach out to our attorney's office and start the proceedings, that they felt that they had exhausted all efforts to, make this a go. Does that make sense?
That's a good summary. Thank you. I have no further questions for you.
Thank you. Ms. Pruitt, do you have any questions for Ms. Claybeck? This is not the opportunity for you to testify, but do you have any questions for her? Thank you. Ms. Claybeck, you may step down. Your next witness, ma'am.
Your Honor, I'd like to call Roberta Wilson.
Good afternoon. Would you come up to this middle podium, state your first and last name, and then spell them both for me, please?
Roberta Wilson, Roberta, last name Wilson, Wilson.
Raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Absolutely.
Thank you much. Please come have a seat in this black chair that is closest to me. Mary Ann's recording your testimony. If she can't hear you, I ask you to either raise your voice or pull that little microphone closer. Yes, ma'am. Thank you.
Good afternoon, Ms. Wilson.
Good afternoon.
What is your relationship with Kirkridge Park Cooperative?
I'm on the board of directors.
And how long have you been on the board of directors?
Next year, I will be ending my second 3-year term.
And do you have a particular title, or are they all just board of directors in equal position?
No, as of now, I'm just like a member at large.
And what are your duties as a member of the board?
To represent the members, to work in their best interest, to solve issues, to work with the property management company to make sure that we get the best prices for things that need to be done on the property, and just to be an advocate for the members.
So in this matter, are you familiar with the issues involving Ms. Pruitt?
Yes.
What is marked as Exhibit 7, and this is the packet of a couple of letters typed. One is handwritten. Well, can you identify these letters?
Yes, these are the letters that are put in the board box. And we're the only ones, the secretary has a key and the president. So we're the only ones that can get these letters out. And these are letters that members put in there when they want to address an issue with us.
Okay, so these are actual letters to the board,
Yes,
and they're from other residents?
yes,
And as you said, they go into a box. So these are not public or mailed. These are things that
No.
only go to the board.
only to the board, and there's a key and a lock, and we're the only ones. Site management, Clearview, no one has access but the president and the secretary.
So as a board member, you were one of the people that received access to these letters to review them.
Yes,
And what is the content of these letters?
these were complaints. They were complaints about issues between Linnell Pruitt calling Chanel different types of names.
Okay, let's break that down a little bit. So they are basically letters regarding the conduct of the occupant, Ms. Pruitt.
Absolutely.
Now, do you have any personal knowledge of what those letters are addressing?
Well, I think it was last year, there was an incident and Ms. Pruitt sat before the board and we all sat there and we talked and discussed some things that she was doing and we all agreed to not to evict, because I'm not quick on doing that and the board isn't either. And so we gave her the last chance agreement and we spoke and she agreed that she would honor those things and that she would do what was said in the agreement.
Now, what was her particular behavior that was so troubling to other residents and to the board?
Well, it was the attacking of the staff, the office staff, Chanel in particular.
Who is Chanel?
Chanel Lett is the site manager.
And Ms. Pruitt was saying things about her?
Yes.
What was she saying?
Well, in the letter that was given to us, the letter had things in it where she was calling her ghetto and hood rat and calling her Shanae. And I know personally that she had wrote in there her maiden name, and I didn't know who she was talking about. So I specifically asked her, well, who are you referencing? And that's when she said to me, well, that's Chanel's maiden name. And I said, well, why would you address her by that rather than Chanel Lett?
Now, you had some problems with Ms. Pruitt before with outbursts,
Yes.
and the issues that you're speaking of, where did those occur?
Well, last year, we had a meeting to remove a board member, Marlena Wiggins. And there was an incident where Marlena was making faces and kind of antagonizing Chanel Lett. And Chanel responded. She didn't do anything. She just kind of stood up. And that's when I heard Ms. Pruitt say, that's who she really is. That's who is. There's the ghetto hood rat. There's Shanae. That's Shanae. And okay, and then that's what I heard.
Let me ask you one more thing. I understand that some of those words are derogatory, not nice, rude. Shanae in particular, though, why is that such a rude word?
Because that was a reference to the Martin Lawrence show back in the day, and there was a young lady that was, I feel, a little ignorant at times and low class or whatever, and she was just a hot mess, okay? And that's where that term came from, Shanae.
So it wasn't a compliment,
No, absolutely not.
and anyone who heard it wouldn't have thought it was.
Absolutely not.
Now, the date of this meeting was approximately when?
It was kind of chilly out that night, so I don't really remember.
Was it in about November of 2022?
That sounds about right.
So that would have been after the last chance agreement.
Absolutely.
That last chance agreement was signed in June of 2021,
Right.
correct? So despite all the problems and the attempts to work with Ms. Pruitt, following prior actions and the last chance agreement, her behavior had not changed and she was not being any more business appropriate with the staff, correct?
Absolutely, yes.
And is that what resulted in this case today?
Absolutely.
So at this meeting, Ms. Pruitt attended as a resident.
Yes.
So in addition to the name calling, was there anything else? Was she inciting other people or doing any other acts?
Well, other people followed behind her and they started making their comments.
Was it an attack only on the manager alone?
It
or
was only
other
on the
people?
no, only on the manager, only on Ms. Lett.
I have nothing else for you. Thank you.
Oh,
Ms.
okay,
Wilson.
praise God. Thank you.
Thank you.
Sit
No,
down.
ma'am.
Hang
Keep
on
your
one
seat.
second. We have to see.
Sorry.
No, you're
Ma'am,
fine.
pause.
Ms. Pruitt, do you have any questions for Ms. Wilson?
Yes, Your Honor.
Now's the time to ask those questions.
You say you represent the tenants, the board, as the tenants. In the event that you're speaking about, that I supposedly said these things, I have text messages that you have a video of me calling a person out there, her name, and all those type of things. Do anybody have that video to show? Because I have proof that she said that this is what I said.
I don't have
Thank
that.
you.
I'm sorry.
And when somebody said that I said this,
Ms. Pruitt, what just happened is the attorney stood up to object and I waved her down. I know what her objection is going to be. It's difficult when someone represents themselves to
Right.
have them focus on question. If you have a question for her, ask the question. Otherwise, if there's a video or text messages that you want to present for your defense, we'll take that up when we come to you, if that makes sense. I know it sounds weird. It's a little tricky to do.
okay, well, the only question I'm asking, if the property manager is attempting to fight a tenant, does the board have an obligation to step in?
That's,
I was gonna object, assuming facts, not evidence.
the objection is there's a whole lot of information packed in your question.
Okay.
And it assumes that there was a fight. There assumes that there was something that was said from Ms. Lett to a tenant. There assumes that the board members were present. It assumes a whole bunch of other things.
Okay.
So you can do one of two things. You can break your question down and get us from, on this date at this time, was there a meeting? Were you there? Was this other person there? And you can ask the questions in that way, or you abandon this question and you ask a different question. That's how you proceed.
I'll just show you my evidence.
When we get back to you,
Yes.
Okay. that's absolutely fine. Anything else from Ms. Wilson?
No.
Anything else?
No.
Thank you, ma'am. You may step down.
Thank you.
Just so you all are clear, there are some Zoom hearings that the court has this afternoon. I have put the attorneys into rooms. I'll take brief intermissions to take their settlements. The attorneys have come back out in our next case to let me know they have a settlement. When we come, or a resolution, when we come back, I'll call you can call your next witness. But in the interim, we have 230233 LT, Rawsonville Woods versus South. May I have your appearances, please?
Your Honor, for the record, Attorney Ian Morton, Appellate's Law on behalf of Rawsonville Woods.
Catherine Cooper with Lakeshore Legal Aid on behalf of the defendant P85148.
Thank you very much. Today is the day and time set for hearing on the defendant's motion to set aside the default judgment. How are we proceeding this afternoon, Ms. Cooper?
Your Honor, I was speaking with Mr. Morton in the breakout room because my client has since vacated the premises on March 31st, 2023. But Mr. Morton informed me that his client did not receive the keys, or at least they can't confirm that they've received the keys. I'm unable to get in touch with Ms. South at this present moment, so we were trying to get an adjournment to kind of work out these issues. I know that there's also an escrow order for this case. Was that a court's request, Your Honor?
It was at my request. Sandy from our civil department brought the file up for the court to accept the motion. And I don't know that it ever was reduced to an order. I don't know how Sandy relayed that information to you. The reason that the court asked for 1 month of rent to post in this matter was that this was a non-payment of rent case, and there were some issues raised in the motion, but none of them was that she did not owe money. And I believe, if I remember correctly, that there were 3 or 4 months of rent that were owing in this matter. That's just what I thought happened, Ms. Cooper. I can't swear to it right this second, but it was because of how the case got from its original filing to the motion to set aside that I asked for 1 month of rent to post. I don't know if it did. I don't see a sticky note that it did.
Okay.
But if you're looking for an adjournment, I'm happy to give it right now.
Thank you, Your Honor.
Will April the 12th give you sufficient time to do what you need to do in getting in touch with your client, Ms. Cooper, and to talk to Mr. Morton?
It should, Your Honor.
Your Honor, I have no objection to the April 12th date. I would just like to confirm, I know Ms. Cooper and I discussed this, and we'll make sure this is still the agreement. We would stipulate to adjourn this motion, but in the meantime, since Ms. South has fully vacated, my client may go ahead and take immediate possession of the premises right now. That's correct, right, Ms. Cooper?
That is.
Okay, and I was gonna prepare a stipulation to adjourn the motion with reference to my client being able to do so, and I can forward that to Ms. Cooper. At the exact moment you give me the time for the next hearing date, I can then put that in, and I will send that to Ms. Cooper immediately.
We will adjourn it until next Wednesday, April the 12th at 11 a.m. If you resolve it in the interim, you can email it over to Sandy. I know that you typically have a Wednesday morning docket, Mr. Morton.
Yes,
Will you be able to appear next Wednesday at
we'll
11?
we'll make it work, Your Honor.
Same question to you, Ms. Cooper. Are you available next Wednesday?
Yes, Your Honor. If Mr. Morton can make it work, we certainly can as well.
I would just,
April, I'm sorry, go ahead, Mr. Morton.
I was just gonna ask, because it looks like on the docket report, it says escrow posted $3,000 with a receipt number. So I know I think that's gonna be the larger issue that the parties are gonna be discussing too.
Well, what typically happens is there's a little sticky note on the front of the file that tells me what they posted and when they posted, and that's not there. That's why I said I can't swear to it. I know what I said to Sandy, but in any event, what we will do is adjourn this matter over till April the 12th, 2023 at 11 a.m. on Zoom. If you resolve it before then, just email it over to the civil at email address and they'll get it upstairs to me. Otherwise, I will see you next Wednesday. It is your stipulated order going to resolve the escrow issue,
Was
the
it,
release or distribution of it?
that's gonna be the goal, that we're gonna be able to do it, but not in the stipulation to adjourn. Was it, because I know Ms. Cooper needs to speak with Ms. South to be able to probably see where her head is at with regards to those funds.
Yeah.
Anything else, Mr. Morton?
Nothing else, Your Honor.
Anything else, Ms. Cooper?
No, Your Honor. Thank you so much.
Thank you so much for your patience this morning. You both have a good day. This
Thank you, Your
afternoon,
Honor.
have a good day.
Thank you as well. Bye, Mr. Morton.
We're back on the record in 23009 LT. The next witness for Kirkridge, please.
Your Honor, I'd like to call Akira Raymond.
Good afternoon. State your first and last name and then spell them both for the record, please.
Akira, Akiria, Raymond, Raymond.
I'm sorry, your last name again?
Raymond,
Oh, Raymond, okay.
Raymond.
Raise your right hand for me, please. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you much. Come up here, please. Have a seat in this black chair that's closest to me. Mary Ann's recording your testimony. If she can't hear you, she's not picking you up, I'll ask you to raise your voice or pull that microphone closer. Thank you.
And I'd like to very briefly apologize. I butchered some names and I feel horrible about that. So I apologize. Would you please state your full name on the record?
Yes, Akira Raymond.
And Ms. Raymond, what is your relationship to Kirkridge?
I am the office manager for Kirkridge.
And how long have you been in that position?
I've been there for about a year and some change.
And what are your duties as the office manager?
Well, I recertify the members yearly. Yes, I'm sorry. Recertifications.
Okay.
Yes.
And what is a recertification process? Does that have to do with the carrying charges?
Yes.
So you help people basically do the paperwork that allows them to
Yes.
stay there at a particular amount?
Yes, ma'am.
So are you familiar with the residents that
Yes.
live there? Are you familiar with Ms. Pruitt?
Yes.
Are you personally aware of any behavioral issues or conduct that was brought to the attention of the management?
Yes.
And what would that be?
Well, it was during the meeting where Ms. Pruitt was pacing back and forth saying things.
So I don't want to interrupt you, but this is that special meeting that was
Yes.
held in November of 2022?
Yes.
And she was there as a resident before the board?
Yes.
Okay, and what was her conduct like?
Well, she was just pacing back and forth, just yelling and saying cruel, rude things to management.
Her comments were not appropriate in
Not
your view as a
appropriate.
professional?
Yes.
And they were directed towards the board, or towards management, or both?
Towards management,
Towards management?
the property manager, yes.
Did she use derogatory language?
She stated,
let me retract my own question and say this. We heard a moment ago that one of the board members said that she used the word ghetto, hood rat,
Yes,
shenanigan.
Shenanigans, ghetto management and hood rat and yeah,
So you heard those words come out of Ms. Pruitt's mouth,
yes, ma'am.
and you also verified that those things were said,
Yes,
and that those are not appropriate for a public meeting
no, ma'am.
at Kirkbridge.
No,
And as a manager, are those the kind of things that also violate the peaceful possession of a unit and people living
Absolutely.
together?
absolutely.
Were there any other occasions where you saw or knew of Ms. Pruitt conducting herself in a manner that would have been unbecoming a resident of Kirkbridge?
No, ma'am.
Did you receive complaints from other residents about this behavior?
Yes. Well, they put it in the board box. I didn't receive them myself.
And what about the actual manager? Did you know if she was offended by this? Did she think it was funny or was she offended?
Oh, she was very much offended. Yes,
Thank you. I have nothing further.
okay.
Thank you. Ms. Pruitt. Your Honor. Thank you. You may step down, Ms. Raymond. Officer Brooks, if you would go out and find out from Mr. Hitchcock if they have a agreement, a settlement. If they do, I'll take a break and we'll do it. Otherwise, we'll start up next. He's the 130 case. Your next witness, please, ma'am.
I'd like to call Ms. Marion Woods, please.
Good afternoon. State your first and last name and then spell them both for me, please.
Miriam Woods, Mirrion, last name Woods, Woods.
Raise your right hand. Do you swear or affirm the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you much. Ms. Woods, same rules. Come up here, have a seat in the black chair that's closest to me. Mary Ann is taking down your testimony. If she can't hear you, I'll ask you to raise your voice or pull that microphone closer.
Okay,
Thank you, ma'am.
no problem.
Ms. Woods, what is your relation to the plaintiff Kirkbridge Park Cooperative?
I'm a member.
So you actually reside there as well?
Yes.
How long have you been living there?
Nearly 4 years.
And what is it that you don't work for Kirkbridge, correct?
No,
What do you do for a living?
I'm a community manager. I manage a different community for KMG Prestige.
So you're familiar with management of cooperative living arrangements.
Yes,
So in this particular case, are you also familiar with Ms. Pruitt?
I don't know her personally, but I recall her from the meeting that we attended.
Were you also present at the special meeting that was held in November of 2020?
Yes,
And do you recall her conduct there?
yes.
And what was it?
She was standing behind me. I was seated in front of her in the last row. There was a back and forth occurrence happening at the front, and during that occurrence that was going on up front, she was yelling, "There go the hood rat, there's the ghetto management," and pretty much antagonizing the situation.
Who was she directing those comments at?
Chanel,
So this is Chanel, we spoke about that as the manager of Kirkbridge.
yes,
Was she directing them at anyone else,
no,
from what you could tell?
no,
Who could hear these comments?
everyone.
About how many people were at that meeting that day? Do you recall?
I don't recall, I would say maybe 45 to 50. It was a pretty larger group.
So that meeting would have consisted of both the board and residents who came forward.
Yes,
So these comments were audible so that everyone in the room could hear them?
yes.
Did you think that they were joking around, or did you feel that they were more of a derogatory nature?
They were derogatory.
Okay, thank you. I have nothing.
No problem.
Thank you. Ms. Pruitt. Thank you. Ms. Woods, you may step down. Thank you, ma'am. Okay.
Last witness, Your Honor, Lawrence Dawson.
Good afternoon, sir.
Good afternoon.
Same
Your Honor.
rules. Do you
My
remember?
name is Lawrence Donnell Dawson,
Spell both your first and last name for me, please.
LAWRENCE, and Dawson is DAWSON.
Raise your right hand. Do you swear affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you much. Please come up here and have a seat in the black chair that's closest to me. Mary Ann's recording your conversation. If she's unable to hear you, I ask you to raise your voice or pull that microphone closer, okay?
Yes, ma'am.
Thank you. Yeah, that chair is not comfortable on a good day.
Good afternoon, Mr. Dawson.
Oh, hello.
What is your relationship with Kirkridge?
I live there and I've been, living there for 15 years.
15 years?
Yeah, because I lived here with my mother, I took care of her. And then when we had to move her, I had my own place.
So you are a resident there.
Yes, ma'am.
Have you ever been involved with the board or you just live there?
I live there, but I do pop in at the meetings.
What do you do for a living, sir?
Let's say I just do a lot of stuff like that.
Okay. Multiple freelancers.
Yes, ma'am.
All right. So are you familiar with the defendant in this matter, Ms. Linnell Pruitt?
Yeah, I've seen her at the meetings.
So were you not even focusing on any particular meeting? Have you been at meetings? You said you've seen her.
Yeah.
So you're present at meetings she was also at. Would you describe her conduct at those meetings?
Yeah, when I was there, I had heard some inappropriate things that was not acceptable. And yeah, I heard the word hood rat. In my defense, I thought that was disrespectful to Chanel. So when I heard that Chanel didn't do anything wrong, what I did was I got up to make sure there was no fighting. Because when it comes to a meeting like that, all we do is just sit and talk about what could be changed for the community.
So when you're speaking about what she said, was that also at the special meeting in November of 2022?
Yes, ma'am.
Were there any other meetings that you were at where her conduct was similar, or are we just focusing on this one event in November?
There's one event.
Okay. So in November, basically, it seems like you heard what everyone else heard.
Yes, ma'am.
In your opinion, was any of that meant as a joke or goofing around or funny?
No.
Did you think that it was disrespectful?
Yes, ma'am.
Did it appear to you that Chanel Lapp was upset by this?
She was disappointed, and to top it all off, I was there to calm her down.
Is this behavior you would conduct yourself as a resident of Kirkridge? Let me rephrase that question. Is this behavior that you stated, Ms. Pruitt, something that you would do yourself as a member of Kirkridge?
What I would do is I would just handle it in the right way. So everything can be peaceful.
Thank you, Sarah. Nothing further.
Thank you. No, Mr. Dawson, not yet. No, Your Honor. Thank you. Now, Mr. Dawson, you may step down. Thank you for your testimony.
And I think, Your Honor, that would sum up the rest of the exhibits we stipulated to would be the remaining 8 is text messages. 9, 10, and 11 are simply discovery between the parties that we're not referencing, but, the judge may want to review. And at that, Your Honor, the plaintiff rests.
Thank you, ma'am. And just so we're clear, 9 as the responses to the request to admit, 10 are the defendant's discovery to the plaintiff, and 11 is the plaintiff's objections and answers to defendant's first set of interrogatories. When the court first called the matter, these documents were all stipulated to exhibits 1 through 11 will be received into evidence in this matter. And I heard you indicate that the plaintiff rests.
Yes.
Ms. Pruitt, as soon as she is done retrieving those documents from the witness box, ma'am, do you have witnesses to call, or do you intend to be the first witness in your case?
My daughter is a witness with a video.
Where is she?
My grandson is out there.
Is she the one with the little, I saw them poke their head in. If you want to go to the door and have her come in. You can come in too. Did she take, well, ma'am, did she take the video or does she just have it?
No, she has it on her phone.
Did she take it though? Is she the one? Okay. Every 15 minutes sounded like a good time 3 weeks ago. That box is tight over there. It's not a lot of room to navigate in. Nothing to do about it now. Well, there's something to do. I don't know. We're gonna do it, but.
Yeah, I think you're awesome.
Oh.
I mean, your demeanor, I mean, yeah, I think that you're amazing.
It's very nice of you. It doesn't sway me one way or the other. Good afternoon. We just need to, Ms. Is she outside with the baby?
Yes,
She can come in,
the baby.
unless you're gonna leave them out there by themselves. It happens. It happens sometimes. The little ones are in here. We try our best.
Yeah.
We've all had a screamer and a runner and a roamer, so it's.
Yeah, he fighting in that time right now.
I saw you in the doorway. I was like, yeah. It's gonna be interesting.
He might get up there with you.
I have nothing breakable that he can reach. You see how I qualified that, right? Ms. Pruitt, bring him forward with you, because if you try to leave him back there, it's gonna be a situation. It's fine. I can't have you out in the hallway during your case. You have to be in here for it. So what we'll do is we'll see what happens. Yeah, I love how this is gonna unfold. You can already see this. Would you state your first and last name for me, please?
Lynetta Johnson,
And spell them both.
LYNETTA JOHNSON.
Ms. Johnson, raise your right hand for me, please. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you much. Please come have a seat up here in this black chair that's closest to me. My secretary is recording your testimony. If she can't hear you, I'll ask you to either raise your voice or pull the microphone closer. Ms. Pruitt, your witness. You can do it from there so he doesn't get.
I would like, for Lynetta Johnson, my daughter, to explain the particular incident on the day that they're speaking of.
She can't explain it, unfortunately. You have to ask her questions. The only person who will be able to sit and narrate, tell the story will be you,
Okay.
because you can't question yourself. I mean, you could, but it would.
Were you at the meeting on that particular day?
Yes, I was.
Did I call anyone or Chanel let out of her name?
No, you did not.
Do you have a video of Chanel in a confrontation with the tenant?
Yes.
With what tenant, ma'am? Just a tenant or
No,
a specific
the
tenant?
board member, Ms. Marlene Wiggins, a physical altercation. Could you, is this a question, can I say, ask her, what led up to the event of me saying anything? Is that a question?
You can ask any question you want to ask, but what might happen if there's something wrong with your question, the attorney might object. But as long as you ask it and she doesn't pop up, Ms. Johnson can answer the question.
Okay, so Marlena was speaking on, she was speaking on the incident, and Chanel stood up from her seat, and it was maybe.
Objection calls for hearsay if she's gonna start testifying as to words.
I'm sorry, what was that?
You can't say, I was in the room and I heard Tony say that Michelle ... You can't say what somebody else said. I try to think of how to say that succinctly.
Unless it's a party, that's confusing to people, yeah, so.
Okay, so Chanel stood up from her seat. And my mother, Linnell Pruitt, said this is how she is, because the people that were there, they were up in the uproar. They were saying that is not how leadership should be. And I have a video of two people holding her back.
Did I call Chanel let out of her mouth.
No, you did not.
In the video that you have, the question is, what you have me saying, did something happen prior or for me to make a statement? Is that a question?
It is a question, but when do you want Ms. Johnson to play the video?
Want me to play it now?
I haven't seen it.
You see me turn to look at you because my question to you was going to be, have you seen it?
It's really quick, but
I haven't. Do we want to see it real quick?
So what we will do is I'll have you approach, if there's one person that you want to have approach as well. And Ms. Pruitt, you've seen this video?
Yes, Your Honor.
So if the two of you would approach and look at the video, and then when you return to your seats, I'll step around and look at the video. And then we'll move from there. Mr. Robinson? You can come up. This is an unrelated.
that's my mom. That's your mom.
Is that the extent of it?
Yeah.
Okay.
That's
If
all
you
she
two would
said.
go back to council table, I'm gonna step around.
That was my mama. That's why she said it the whole time. And that's what Chanel, when they see the two people holding her back.
Ms. Pruitt? Question? Question for Ms. Johnson? Just so the record's clear, the witness, Ms. Johnson, has a video that is just a few seconds long that shows chairs and tent outside. It appears to be in the evening. Not really, I think that accurately describes the extent of the video, correct?
Yeah.
We'll call it a video.
Yes.
Accurate description of the video?
Yes, Your Honor.
Do you have any other questions for Ms. Johnson?
No, Your Honor.
Thank you. Your witness, ma'am.
Ms. Johnson, is that video that you just showed us, is that cut off in any way?
It's cut off. I was holding my son as usual. Sorry.
Okay, so there was a lot more after that, correct?
No more was said. That's all she said.
That's not what I asked you. There was more of the meeting and everything after that,
Yeah.
correct?
Yeah.
Okay. Ms. Johnson, are you a resident of Kirkridge as well?
Yes.
Do you actually, you live with your mother or in a separate unit?
Separate unit.
In a separate unit? And how long have you been there?
2 years.
Okay, I have nothing further for you. Thank you.
Thank you. Do you have any more questions for Ms. Johnson? Thank you. Ms. Johnson, you may step down. Thank you for your testimony. Mr. Robinson?
Good afternoon, Judge.
Sir, I am in the middle of a trial. There is another hearing scheduled at 1:30 that we're bumping up against. If you have a settlement with Ms. Frynulik or some update, I'll take it from you right now. Otherwise, I'll get to your case as soon as possible.
Judge, we don't. I've tried to call sister counsel and the phone number on the pleadings, it goes to a voicemail that has no voicemail. So I haven't had a chance to talk to her.
If she's not here by about 2:15, I'll call a case and proceed from there. Mr. Hitchcock has the 1:30 case. We just start taking the defense to the 1 o'clock case. So sit tight. I'll circle back to you as soon as I can.
Judge, would you mind if I jump over to 36th District Court? I got a quick traffic matter I got to do. So I'll jump over there and jump back if that's okay.
When you come back, I'll admit you again, and you'll understand if I don't come right to you, it's because I'm still in session on the in-person cases.
I appreciate it, Judge. Thanks.
Thank you, sir. I am so sorry for the interruption, Ms. Pruitt. Are you ready to testify or do you have another witness? Ms. Pruitt, if you're ready to testify, do you want to testify from there? It's, you testify from the table or you can, hold on one second, because so you understand. You'll testify from the table or you'll testify from the witness stand because you'll be sworn in. And after you get done telling me what happened, you'll be cross-examined. So you won't do it with your back to the attorney. So wherever you're more comfortable is where you'll go.
I'm fine. I come over there.
Before you go over there, raise your right hand. Do you swear from testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you much. Come up here and have a seat in this chair, please. Ms. Johnson, if he's a lot for you, you want to go back out in the hallway, that's fine. What is it that you want to say that you believe is a defense to the notice to quit that was served upon you to terminate your tenancy at Kirkridge?
I would like to say that first off, everything other than saying that this is who she is, everything else is a lie. I would like to say, as in my evidence, that she texted me, you see, the exhibits, request for admission. You have the one where she texted the information of the text.
There was a group of texts received
yes.
and paper clipped together
Yes.
as number 8.
Yes, Your Honor.
Where is it that you're directing the court?
The first text, all the texts, when she calls me, when she texts me at 7:16 in the morning and calls me ignorant. And it says, you will be receiving something in the mail very soon. Your disrespectful outburst telling members you called me Shanae. You lied to the board and said it was a typo. Calling me ghetto rats is just being plain ignorant the whole time. My response, I said nothing of the nature. See you in court. Her response is witnesses and they recorded you. See you there. If you're gonna accuse someone of something and say that I said this, then it was enough room for video. It should be a video of me, because she told me, her text says she has a video of me saying this. I said, this is how she is because she got ready to fight Marlene Wiggins in front of 30-something people. In front of 30-something people. The video that my daughter shows you is a member getting in the middle of Chanel and a person. The lady was talking. Chanel got out of her seat, just like where you are, and came up and got in the lady's face. This went on. No member said nothing. Ready to fight, or I should put Joe out of here, and this.
Wait a minute, is this hearsay? I don't know.
No, I was there. No, this is what I heard.
Who's saying this?
This Chanel
Well,
saying this
that's
to
hearsay
Marlene.
then, that's hearsay.
I was there. Oh,
No,
okay.
you were there, but it's your repeating what somebody else said.
Okay.
I'm not taking it as the truth of the matter asserted. I hear you, and I know it's difficult when you represent yourself and you're trying to put your case in chief on. I hear you. You can proceed.
And after it continued so long, it was fearful that she was gonna fight the lady. And I said, this is who she is. I walked from the front I walked from the back to the front and said, this is who she is. This is who she is. You cannot fight people in front of other people. This is what I seen. And the video is where my daughter shows the brief clip of a person intervening to keep the two apart. This is the property manager. If we cannot disagree without being attacked physically, then there's something the matter. If I did something so wrong that she told me she has a video of me saying this thing, I said, present your video. if I said these things, because I did not say these things. In all my statements, I'm saying you're trying to fight the lady. This is all my evidence that you got up there. That you're trying to fight the lady in front of all of us, that's not appropriate. Then you text me at 7:16 in the morning and call me ignorant. I've never been experienced around a property manager of that nature, that you have to be fearful of what you can say. And then to say that I said the things that I didn't say, nobody acknowledges that this property manager got up in front of everybody and tried to fight the tenant.
Objection, Your Honor, assuming facts not in evidence.
And those are my evidence, and those are the questions, and then you have the questions that I asked the, you have all the information.
I do. The copies of your questions to the plaintiff, your discovery request. Was there something else?
I was just waiting to see the video that I called these names that I know that I did not do.
Thank you. Your witness, ma'am.
Your Honor, I have no questions.
Thank you. You
Oh,
may
wait,
step-
actually, I retract that. I have one quick question. Ms. Pruitt, Exhibit 4 was entered into as a conditional occupancy agreement, a last chance agreement. Why did that come about?
That came about because Chanel called me 20 times on the phone telling me that my rent needed to be at the market rate. She took all my W-2 forms and check stubs and didn't return one, and politely gave my check stub, not in an envelope, to the maintenance man and brought down to me. And I felt that that was my personal information that should have been protected the way I protected it. So that led into the disagreement.
I would say that's non-responsive. You signed a last chance agreement on June 29th, 2021. Correct?
Yes,
Do you remember doing that?
yes,
Now, at the time, was there another termination proceeding against you?
yes.
And what was that for?
What I just stated to the judge.
Oh, so you're saying that was the basis of the termination?
That was the basis of the termination.
So you resolved that by entering into this agreement.
Yes,
Did you enter into this agreement freely and willingly?
yes,
And did you sign a statement that you would be under probation for 2 years
yes,
from that day to June? And during that time, that you would in no way basically disrupt the peace or create a nuisance or interfere with the health, safety of anyone else at the complex, including the staff?
I signed that, and I did not interrupt.
There's no more questions before you. Thank you, Your Honor. I have nothing further.
Thank you. Ms. Pruitt, was there something else you wanted
Yes,
to
Your
say?
Honor. I did not interrupt a meeting that was going on. I interrupted a verbal attack between the property manager. I didn't interrupt it. As the video said, I was on the side. I don't want to see nobody fight. So the meeting was already interrupted the moment the property manager jumped up and got into the person's face. There was no longer a meeting of the minds. It was a safety issue.
Anything else?
No, Your Honor.
You may return to the table. Ma'am, before you give your closing argument, just so we're clear, you're attempting to terminate Ms. Pruitt's tenancy based on the comments that were made to Ms. Lett from this November 22 meeting. Not from anything else, but from name calling that your witnesses claim, name calling that your witnesses have to testify occurred on at the November 2022 meeting.
Correct.
That's it.
Yes.
No other claims, no other no.
To the extent that the probationary agreement was to resolve a prior issue, those parts are also at issue, still at play, that there was a prior termination. It was resolved by the probationary agreement, and then those acts violated the probationary agreement.
Okay,
So it's kind of a long string.
your closing arguments, please.
Your Honor, when parties choose to live together, whether they're working together every day, living together in a commune, in an apartment, in a co-op, in a single-family residence, it's difficult. So there are extensive rules and regulations. In this particular case, we have lots of them. We have an occupancy agreement, we have bylaws, we have rules and regulations. It is the position of the plaintiff that those were violated in the past by the resident, Ms. Pruitt, and they gave her a probationary period and a last chance agreement to stay there if she didn't do it again. And it is their position that she did do it again with her conduct in November. And why that is so important is the probationary agreement specifically says in paragraphs 2 and 3 that the members agree no act will be committed by them, their household, going on, enjoying the peaceful possession of their home, including but not limited to public areas or any other privilege or amenity available to the use of Kirkridge premises. Members shall not approach other co-members about their concerns or complaints. They shall bring them right to Kirkridge. And then number 3, that they are specifically not to interfere with the health, safety of others, including or not interfering with any Kirkridge staff member, employee, manager, contractor, or board members in the performance of their duties. So it is our position here today, Your Honor, that within those rules, her conduct at the special meeting, after her behavior in the past, she was on notice. And her conduct with insulting a manager not only got other people riled up and was disturbing to their peaceful enjoyment of a meeting, but was inappropriate towards a staff member. So we have had 5 people come in today, of which 4 were present there and said that these things were said. It can be trivialized, oh, in the heat of the moment and whatnot, but the bottom line was she was on notice that she couldn't act this way anymore. And she said things that were very derogatory, that were not helpful to a meeting, that were not helpful at all to a meeting, and were certainly insulting to a manager. So that directly violates this last chance agreement, number 4, exhibit number 4, that she agreed to. The only testimony that she has today in defense of herself was that she was trying to defend someone, and there's just been no evidence that anybody was in danger. And also her daughter, who came in with a briefly cut off video that was essentially self-serving, but it does show enough to verify what the other witnesses stated, that Ms. Pruitt came into the meeting and was pacing back and forth and then began to say, that's her, and it cuts off where it says, that's the regret, that's the, all the other things. And I think that that video does establish what these people were saying when they witnessed her come in and be mildly upset and then get more and more engaged and more upset at the meeting. At this point in time, we are asking that her membership be terminated. It would be terminated in accordance with the rules and regulations because she does have equity. So her shares would be sold and that unit would be sold to someone else. And any remaining equity would go back to her. And that's what we're asking for in this proceeding. We don't think that she can live there peacefully with any of the other people anymore. And I believe it's clear from the testimony, yes, some of the people are board members and management, but some of the other people are uninterested parties that are just trying to live there, trying to form a community. And in the best interest of everyone, she's violated this agreement and Kirkwood should be able to go forward with their termination. Thank you.
Thank you. Ms. Pruitt.
Yes, Your Honor. All the guidelines apply to the tenants. Nothing applies to the property manager. Her behavior, her conduct is unprofessional, disrespectful, calling people ignorant, getting up in the board meeting in front of everyone saying that. And her text directly says that they have videos. If my daughter took a clip of video, some of these other tenants, everybody is taking videos. They would have shown me saying the things that I did not say. So therefore, they could not present a video of me saying something that I did not say, Your Honor.
Anything else?
No.
Here's the issue and the concern. The court has heard the testimony of quite a number of people this afternoon and has had the opportunity to read sections, paragraphs 3 and 4 of the probationary agreement. Paragraph 4 specifically indicates that no form of electronic communication, not limited to text, email, messages, fax, otherwise, be transmitted by members to any Kirkridge staff member, blah, 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 with threatening language, disparaging remarks or vulgarity of any kind. And then there was paragraph 3, that the members will not act in a way that interferes with Kirkridge staff members, employees, et cetera, performing their duties. And there is some concern about what happened at this November 2022 meeting. The clip that Ms. Johnson presented does not show what led up to it or what happened afterwards, and it's difficult to make out who was in the video. It is crystal clear to this court that there was a disruption that occurred at that meeting. What's not clear to the court is that Ms. Pruitt did anything to hinder or interfere with any staff member, employee, manager, contractor, board member from performance of their duties. The text that was presented to the court, there's nothing highlighted that shows that Ms. Pruitt sent disparaging remarks, threats or threatening language to anyone from the Kirkridge side of things. It's clear that there was some inappropriate, I consider calling a member ignorant. I consider that inappropriate, and that's clear in the text messages. I don't think that the intent of anyone would be to have someone lose their housing somewhere they've been since 2015 over, I don't want to be called a ghetto rat or a hood rat or shenane. I don't, this court doesn't, but that does not seem a sufficient basis to find that someone has interfered with staff or has been threatening or vulgar in the electronic communication detail. Ms. Pruitt, that's not helping because it shows the court that you're unable to maintain your silence and patience. And I'm saying this all out loud because as the court has taken in the exhibits and the testimony this afternoon, it is clear that something happened. The witnesses have taken time out of their day to come forward to swear under oath that Ms. Pruitt made the comments that she made. Now, Ms. Pruitt, your daughter gave us a super short video about what happened that night, but something happened. People were willing to send letters into Kirkridge. People were willing again to come in and testify this afternoon. Your behavior, whether it was screaming out, that's who she is, or hood rat or shenane or whatever it was inappropriate at that night. But this court will not find that it rises to the level of supporting your termination of tenancy and will deny the request for relief in the plaintiff's complaint. What this court will say to you, ma'am, is that you remain under the terms of the probationary agreement. And the fact that that agreement came out of some prior issues and you could not contain or would not contain yourself or absent yourself from that November 2022 meeting makes the court concerned that this is not the end of this. I would caution you that if you are back here again with Kirkridge, whether it's back here in courtroom number 1 or one of the other courtrooms in this building, I don't know that you will receive the same grace. I won't lecture this afternoon. The plaintiff's request for recovery is denied in its entirety. Anything else on behalf of the plaintiff?
No, you haven't.
Anything else, Ms. Pruitt?
Thank you, Your Honor.
You're welcome, ma'am. That concludes this matter. The Civil Department will prepare the judgment showing, denying the plaintiff's request for recovery, and that will conclude this matter. Thank you.
Yeah, thank you for your opinion. Have a good day.
You too. Thank you, ma'am. You're free to go. Would you please? Ms. Froniuk and Mr. Robinson, I have a moment before I call the 130 case, if you're ready.
I'm ready.
Mr. Robinson is back. Mr. Robinson, are you done with your traffic matter?
Yeah, I just got done with the judge. I just literally just hopped on.
This is, I saw you coming in. This is 230179 LT. This is Sunbeam Property Management versus Oakley and Robinson. May I have your appearances, please?
Good afternoon, Your Honor. Attorney Kiana Framulik, P73015, on behalf of Sunbeam Property Management LLC.
Good morning, Your Honor. Steve Robinson on behalf of the defendant.
Thank you. Today is the day and time set for trial in this matter. Ms. Fryulik, how are we proceeding?
Your Honor, I hope the parties would be able to reach an agreement. There's been no agreement reached. So at this time, unless Mr. Robinson is agreeing to enter a consent judgment to him, for him to vacate within, the allowed timeframe, I guess we have to move forward.
Mr. Robinson?
Your Honor, as I indicated before Sister Counsel appeared, I tried contacting her earlier today and there was no voicemail. If we could go in a breakout room briefly.
What I will say to you is I will put you in a breakout room. The case that was scheduled to start at 1:30 is in the courtroom now. So when you come out, unless you have an agreement and you indicate that in the chat, the court will conduct the 1:30 trial. And then both of you appear, and I don't see any witnesses, so you're not ready for a 2 o'clock trial, but go into this breakout room. I'll send you the invitation right now. And when you come back out, I will call your case as soon thereafter as possible. Thank you.
Thank you.
This is 230248 LT. This is Romulus Housing versus Tequila Standifer. May I have your appearances, please?
Good afternoon, Your Honor. Steve Hitchcock appearing on behalf of Romulus Housing Commission.
Thank you. Let me apologize to both of you for the delay. Our 1 o'clock took a little bit longer than anticipated. Today is the day and time set for the trial in this non-payment of rent matter. Mr. Hitchcock, are you ready to proceed?
Yes, we are.
You have all necessary documents and witnesses.
Yes.
Ms. Standifer, same question. Are you ready to proceed this afternoon?
Yes, ma'am.
You have all necessary documents and witnesses.
I have documents, but my witness is not able to be here.
Are you ready to proceed?
I can proceed.
Thank you. Do you have any opening statement, Mr. Hitchcock?
No, Your Honor.
Any opening statement, Ms. Standifer?
Only that I don't even know why we're even in trial right now, because none of it makes sense, Your Honor. I've made payments every single month, and they're telling me that I didn't pay an amount when they didn't have an amount to give me. They didn't have the right amount for me to have to pay them. I shouldn't be in court paying for something, but I didn't have the right amount.
Thank you. Your first witness, sir.
Hold on, Melissa.
Mr. Hitchcock,
One.
My apologies. We lost our Polycom for a second there. Ms. Standifer? You have reviewed the ledger presented as plans exhibit number 1?
Yes, ma'am.
Mr. Hitchcock has moved for its admission. Do you have any response? Ms. Sandifer, you'll have the opportunity to question Ms. Bullis about it, but as for it being a business record of the plaintiff, do you have any objection to the court receiving it? The court will receive the ledger.
Thank you. And can you give us, court, a little bit of history on how rent rates are established for tenants in the housing commission?
Sure, their total income or cash equivalent into the household is totaled up. They receive a deduction for each dependent, and then it's 30% of that rate is determined to be their base rental amount, and they receive a utility allowance based on unit size to get the net rental amount.
And I think a minute ago, you couldn't identify back when this rent was established. I'm going to show you another 2-page document that I put exhibit 2 on. Can you identify that for us?
Yes, this is the household information sheet of the last completed certification dated January 1st, 2022 at the rate of $742 per month.
And that was signed by the tenant defendant in this case?
Yes, it was.
Ms. Sandifer, have you received this document, reviewed it as well?
Yes, Your Honor.
Apologize, we don't have an extra copy.
No worries.
2-page document I would move for its submission.
It's received.
And then how often are tenants' rent levels examined?
They're done annually unless the tenant indicates a change in household income or composition. Then an interim is done between annuals.
So the one you just looked at, exhibit 2, was that an interim?
Yes, sir, that was an interim.
So that Mrs. Stanifer would have made a request to have her rent re-examined based on what she thought was changes in her household income?
Yes, sir.
And did that result in a change?
Yes, it lowered her monthly amount.
And then at the end of last year, was she then subject to the annual review?
Yes,
And has that been in process?
yes.
And if you know, are there, what are the rules or regulations under which you deal with determining the household income of a tenant to establish the rent?
Any monies that come into the household on a regular basis are considered income, whether from employment, social security, cash contributions from outside sources, they're all considered income.
Are those rules that you apply that are established by HUD?
Those are HUD's regulations, yes, we must abide by them.
The Romney Housing Commission receives funding, HUD, is that correct?
Yes, sir.
Therefore, you have to follow those regulations.
Yes, sir.
Have you experienced any difficulty in establishing any new rent rate or determining whether the current rent rate is accurate with regards to Mrs. Stanifer?
Yes, sir.
Just give us a quick brief description of what issues you've had.
We've had trouble getting explanations for money coming into the household, cash contributions, bank transactions, getting background on those things so we can establish either way. We can't complete the cert until we have full disclosure of where the monies came from and why they were contributed to the household.
And what is, what is HUD's rule with regards to the rent of the tenant during the process of trying to reevaluate their rent?
It is standard practice that you continue to pay your established rent until your new certification has been completed, the resident signs it, and also the agent signs it.
And in this case, the Exhibit 1 carries the same rent that was established in Exhibit 2, is that correct?
Yes, sir.
Do you know approximately how many accounts Mrs. Sanford has?
I believe there are at least 5 bank accounts and some cash app accounts.
From your point of view, has there been cooperation from Mrs. Stanford in giving you the details of the transactions that go through those 5 accounts?
Not direct answers to direct questions.
So as we said here today, is there or is there not any new recertification for Mrs. Stanford's unit?
Not a completed one. We're still waiting on clarification on the bank account transactions and the cash app transactions.
I have no further questions at this moment. I may need her for rebuttal, depending on.
Thank you.
And it does.
Ms. Standifer, do you have any questions for Ms. Bullis? Now, this is not the time for you to testify. It's questions to her. And you can remove the gun before you start asking questions, please. That's okay.
Yes, I'm nervous.
Why are you nervous?
I've never been in court before.
And yet here you are and everybody's fine.
Yes, ma'am. So just ask like any question that I want to ask pertaining to what he asked, or, I don't know.
It's a non-payment of rent case.
Yes, ma'am.
So your questions get to either the balance, the certification, her testimony regarding your, okay.
So she said that she's responsible for the paperwork, so can I ask her about that, because the paperwork is,
Absolutely.
okay, so she said you're responsible for the paperwork. When I brought all my check stubs in the first time before I emailed them, they were lost. So you were saying that you were waiting on something. I've been getting my check stubs since September of last year when I called to report my income is missing. So was that on you for that mix up? Because who am I emailing or who am I sending things to? Because you're saying that.
Ms. Standifer, the question, no, you're fine. The question to her is, did I send you my statements? Did you receive my email? That kind of, when you ask a lot of questions like that, when she gets to the end, she's only going to answer the last question. So break them into smaller bits.
So were you the person responsible for my bank statements being lost or us having to prolong?
No, ma'am.
But you just stated that you were responsible for the rent.
Yes, ma'am.
Okay. Also, did you not get any of my oh, I'm sorry, there it is. You said that it's required that I keep my same balance into the certification account.
I'm sorry, I didn't.
You said that it's required that the tenant pays the same amount of rent until the rent is done, until the certification is done.
Yes.
Would you have any idea why Bianca would tell me to pay $300 a month instead of $742?
I cannot speak for Bianca.
Okay. And then you said you've been having formal confirmation from me. I've been very, very cooperative. What problems have you had with confirmation or confirming anything from me?
A list of questions was emailed to you yesterday. Numbered list to be answered for clarification on the banking. And it was not returned with answers to the questions.
I replied, I don't know if I can submit that to the court or
When-
anything. I replied yesterday.
Wait, hold on one second. What will happen is, when you're done asking questions, Mr. Hitchcock might have other questions for her. And then if he has another witness, we'll call the other witness. When I turn to you to put on your case, you can give your testimony regarding what happened with these most recent round of questions or prior submissions of documents. That will be your time to do it. But right now, it's just your questions to her regarding either her position or the record keeping or something specific that she has knowledge of. Okay, thank you.
You need to find regular basis for me for income, you said regular basis, but I don't know, what does that mean?
I don't understand your question.
You stated that any income that comes into the household would be regarded as an income. As long as it came on a regular basis, can you define a regular basis?
More than one time.
There are payments that you're asking about that only occur one time. Would that still be qualifying as an income?
It depends on the explanation.
Because you just said that it's a regular basis, it becomes more than once. That's what the definition was. If someone gives you something once, then it's not a regular basis, right?
Correct.
Then on there, when you're asking about one-time payments, why are you asking about it if it's not a regular basis, so it's not an income?
I haven't asked about anything.
You have one-time payments for my balance in order to add up what my income is. You've asked about any deposit that I've had. You have asked about every deposit I've had. You have.
Is that a question?
Yes. Haven't you asked about when you are doing this? Are you asking about every deposit that enters the account?
No, multiple deposits into multiple accounts. So that you can provide an explanation.
I don't have any questions.
Thank you. Any redirect, Mr. Hitchcock?
No, Your Honor.
Thank you. Ms. Bullish, you may step down. Your next witness, sir.
I have no further witnesses.
Thank you. Nope, you take that back to him, please. Ms. Standifer, we're now to your defense to the claim. I'll swear you in, and then you can give your testimony. You may give it from either where you are, or you can come up here and give it. After you get done telling the story or offering your defense to the non-payment of rent case, Mr. Hitchcock will have the opportunity to cross-examine you, okay? Raise your right hand for me, please. Do you swear or affirm testimony you give in this matter will be the truth, the whole truth, and nothing but the truth? Thank you, ma'am.
So this case started August of last year. Is that where we're going back to now? I'm telling my story, right?
You're telling your story.
Okay, so it started last year. I had a medical leave from work and I was on disability from August to November. Immediately in August, I called to let them know what was going on with my situation because I know that my income and my rent go together. So I let them know that. Immediately, they started to ask about the check stubs and everything. I physically brought in my check stubs and everything. She told me to continue to pay the rent.
She who?
Sorry, Miss Paula told me to continue to pay the rent until it was figured out. Your Honor, I had already submitted my check stubs long before then, or they wouldn't even started on doing anything for me. They can't start it. So from all the way September, October, November, December, I paid the $742. In September, they sent me a check for $444 for disability. So I just still paid the rent. October, I didn't have any money at all. November, I got a check for those 2 months and I showed them that and I gave it to them. What was definitely holding up my case or whatever they were doing for me was my sons. what happens is that they turn 18, and so they have to sign paperwork for their income, because 2 of those incomes was for social security checks for my sons who are disabled. Once they got older and decided that they didn't want to come sign paperwork, it fell on me. I can lose my housing for that. It's what, how Ms. Paula explained it to me. So that's what took so long. It was never me not being cooperative. I've always given all my information every single time. So after coming into this year, I talked to Bianca, and that's why I started to pay $300. I would never just start paying $300 when my rent was $742. She said that after everything was all done, that it would be okay. December last year, I talked to Ms. Paula, and she told me to pay $1,000, and she would rip up that shut off the eviction notice. So in December, when you see that 500 payment, it's from when Ms. Paula told me she would rip up the eviction. Come to find out, there's another note on my door, and I'm actually in court right now because she didn't do that, and they didn't correct anything. They didn't do their part. They were still not done. I came in to certify my stuff not once, not twice, but 3 times, and Ms. Paula said that Ms. Bianca didn't do any of the information. So I've always been there. I even went to the state and applied for help, and they were going to pay $1,040 for me. Ms. Paula was so disrespectful to my worker. It was unbelievable. She said she has never been so disrespected in her whole career. I'm sorry, I'm getting upset. She got her supervisor involved. She said she's willing to submit the emails and everything because she said it felt very personal that she did not want to help me. She refused to give her name to her. She refused to give anything. When I paid the amounts, I came in and paid my portion of the SER, and she just needed a letter from them. When I came in there, she talked to me so horribly that she couldn't believe it. She said, "Is this what you do? Is this what you deal with all the time?" I said, "Yes," because she belittles everybody that comes in that office. When I came in there one time, I sat there for 40 minutes waiting on her for a meeting, and she just completely was just so disrespectful, it makes no sense. And I have it on recording. Nothing was done, Your Honor. They're putting it on me, but their part was not done at all. I've constantly submitted everything they've asked for. And then they email me and say, "Oh, we're missing April and August for last year." So I emailed her back the check stubs or the bank statements or whatever it was. Yeah, the bank statements. I'm sorry, I gotta be correct. I emailed her back the bank statements. And this is the second time, because mind you, I bought them bank statements with 3 bank accounts. I only have 3 bank accounts. I have 1 bank account that I was working, that was for my job, 1 bank account for Brandon, 1 bank account for Brian, and 1 Cash App account. I haven't seen anything. As a matter of fact, this right here, this is my life. Every single dollar that I've had, they've asked me about it. This is from a $12,000 stimulus tax refund that they're saying is income. They make me come in here and write every single thing, page after page, for what I got money for. What did you get this for? Who was this for? Who was this for? Me and my daughter sat there for over an hour and a half, 2 hours doing this. And she's saying that I'm not cooperative. I have been nothing but cooperative, nothing but respectful. And I don't even know, like I said, I don't even know why I'm here. I don't know, because it's just for non-payment. But I've been paying every single month until someone told me to pay 3. Then I paid 3. I haven't missed 1 month. I don't know.
Anything else, Ms. Standifer?
Yes, also that she told me this was attached to another case. So not the case that she said she would rip up after I gave her $1,000 after I had to take that out of my retirement money and being penalized for it. After she said that, this is a new case, but I don't know how this is a new case if that was December. And then I'm right back in court for what? What am I? And I've been paying January, February, every month. I've been paying $300. I don't know why I'm here. If I paid $1,000 and she tore up the note, where did the other what happened?
Anything else, Ms. Standifer? Before Mr. Hitchcock starts his cross, if he wishes to cross-examine you, the court is looking at the ledger that was attached to the summons and complaint, and it shows a 0 balance after the September 2022 payment. The summons and complaint filed in this case shows the defendant current paid through November 2022. When we were last here, Ms. Standiford, you made the comment to the court that your rent was supposed to be $601 per month. So I'm sorry, you didn't make that? He made that comment. I'm sorry. Mr. Hitchcock made that comment. So where we are is a discrepancy over the balance due.
Yes, ma'am.
Okay, so you said a lot of stuff about other issues, SER and
Yes, and that was going for
the tone of,
balance. I'm sorry.
the tone of comments that Ms. Bullis has alleged you have made to SER or your worker. But we're focusing on the numbers. So we will turn to Mr. Hitchcock for his cross-examination. Ms. Standiford, I'm going to have you move so you can come over here, sit in the witness stand for me, please. You remain under oath. It's a lot easier than having him pivot that thing around.
Mrs. Stanford, let me show you what I've marked as exhibit 3, which is one of your bank statements, one of the periods of. Is that correct? And it shows that the deposits into that account for this month period, which was March 24th to April 26th, $6,401.
That's what it says.
And then on exhibit 4, which is the next monthly period, April through May 24th, same account, that shows deposits of $7,137. These are your bank records, is that correct?
I'm sorry, your response, ma'am?
Yes.
And this is exhibit, proposed exhibit number 5, which is a period of May through June 24th. Same account. And that had deposits of $7,000 into that. Right?
Ma'am, you can either, no, you're fine. Either sit back or pull the microphone up. Mary Ann's just not able to pick up.
Sorry.
And then exhibit 6, proposed exhibit 6, that's June through July. Again, your same account, is that correct?
Mhm. Yes, it is.
And that one had $6,084 deposited.
Ma'am,
Yes.
you all aren't talking to each other. You're talking to me and Mary Ann as well.
Thank you.
And then exhibit 7 is August, September, and the same account that had $5,532 deposited into it that month. Is that correct?
That's what it says.
Again, this is your account.
So, ma'am, you have to keep your
Yes.
voice up.
Yes.
I would move to admit exhibits 3 through 7, Your Honor.
Thank you. Mr. Robinson, Ms. Franulik is waiting for you in number 1, please.
And besides this account, you had at least a couple of other accounts, is that correct?
What's a couple?
And you actually have one account that you're using the last name of Johnson, is that correct?
I'm sorry, what is a couple accounts?
Don't have to touch it. Just keep your voice up.
Yes, payday loans.
Okay. And why do you use so many accounts?
Why? Because for Social Security, you have to have a certain account. That's why one is custodial, and then the other is for the other check, and they go directly to those accounts. I need my own account for working so that I can have my checks deposited. So that's why I have 3 accounts,
Why do you have one in the name of Johnson?
because I'm married.
You-
I got that account when I was like 19 years
Miss
old.
Standifer,
I'm sorry.
listen, you started by saying you were nervous, but what happens is Officer Brooks is gonna come over and he will adjust the microphone. If you would sit up and just answer the questions, I know it's difficult. It would make it a lot easier. I think we're having a situation.
I'll treat it like a mouthpiece now. Don't touch me.
So,
Because she's married was the response to your last question.
is that your last name now, Johnson?
No,
But you're married to a person whose last name is Mr. Johnson?
no.
So why are you, I'll ask the question, why are you using the name Johnson? Is that a maiden
Because
name?
that's the name I was born with.
Okay. Maiden name is Johnson. Does Mr. Stanifer live in this house with you?
No, he doesn't.
But he does provide you with, according to these records, with monthly income. Is that
No,
correct?
he doesn't.
Well, he provides payments to you,
No, he doesn't.
never provides you any payments.
Every now and again, he does.
I have no further questions.
Thank you. Ma'am, is there any testimony you'd like to give in response to the questions that Mr. Hitchcock just asked you?
Yes, Your Honor. The accounts that he's showing big balances to, the reason that there's big balances and it is moving so much is because I'm moving the money from one account to the other. And those transactions are all on my bank statements. You can see that it's not just deposits. Also, some of that time I was working. I've been working all the way 8 years until a few months ago until I couldn't work. So I had income that I was able to have in my accounts. Also, like I told her, those papers that I just had back there, Your Honor, was me going through every single last one of those transactions. And I had to put it on that paper and show them and tell them where it came from. I moved that lump sum of money to 3 different accounts. Sean was helping me pay my bills because I need help managing my money because of a disability that I have. And like I told her, you can see me send Sean like $3,500, $3,000, whatever it was, and then he would send it back to me if I asked for money, if I needed to pay something. But you can definitely see that it came from me and went to him and came back to me. And I even stopped doing that once I figured out that I can send the money from the Tequila Johnson's account to Tequila Standard because it's 2 different names. So I even stopped using Sean after a while. But that's why it was going to his account and into my account because I was trying to avoid having to go to too many banks to put my money where it should go.
Thank you. Anything else?
Yes. My rent amount was $610. How would it lower if I had more income? And I never got anything that said my rent was $610. That was just verbal. Is there anything that says that?
I don't understand the question.
Why does everybody insist on touching that thing? Well, I said it, Mr. Hitchcock, and I might have added to the confusion. My notes were from March the 15th. $601 per month is new rental rate with a total due of $2,590. That was my note in the file, and I thought it was Ms. Standifer that gave that information. Ms. Standifer says it was you that gave the information, the $601 per month, but ignore, if neither of you said it, and I just made up a number and a total past due rent, then ignore me.
I don't recall saying that was the rent.
Are those? I'm sorry, am I allowed to ask questions? I want to know if they were recorded because it's definitely, if it was, then it's recorded because I heard the same thing you heard, but I heard.
But that, Ms. Standifer, that's why I'm saying, if the court has confused the matter, ignore it because that's more my comment and my note to myself. What we have is a ledger history report that shows $742. We have the household information from March 5th of 2022 that shows the tenant rent of $742. If there is something else in writing that shows a different rental rate, the court would entertain that, but the only thing in writing is $742 per month.
Yes, ma'am.
Did you have a question other than that?
No, yeah.
Did you have any other comment, ma'am?
Yes, I was just wondering, for those big deposits that he had, are we going to be able to go through and see that those were my money sent to that account, and that someone didn't send it to me, or how does that work? Because yes, that it is showing that, but when you look at the statements, you'll see that I sent that money to myself. And I had to write all of that down. Is that proof for the court for all of the transactions and explanations, or no?
Today is the day and time for the trial. The first time that the parties appeared with me was on February 22nd, 2023. And if the issue was the documents that were provided for recertification or an adjustment to the rental rate, that is something that you parties should have worked out with each other. I am happy to pass the matter so that you may have conversation if that's what you want to do. But if it's your testimony under oath to this court that you move your money around from account to account and from Cash App to account and giving to someone else to hold and then transfers back to you, that's an awful elaborate story to make up if it's anything other than what you say it is. But it's not my case, it's Mr. Hitchcock's case and it's your case. So if you want to give testimony about the moving of state of money, that's your absolute right. But Mr. Hitchcock has cross-examined you. He's concluded his cross-examination. It's a question, not a statement.
Yes.
So typically, it would be redirect where your attorney would ask you more questions, but because you're in pro per, this is your opportunity to respond to the questions that Mr. Hitchcock just asked you. If there's something specific you want to say in response to the questions he asked, this is the time. Otherwise, you'll return to the table.
Okay, so in regards to my balance, I've submitted all of the income and all of the proofs and what they have now. When will the rent change? Why has it not changed? Like, how is this still the amount if they're still going from 742? They didn't come to me before the court date, like Bianca said she would, with the new amount so that we can figure it out and have it paid off. I'm just still not getting why I'm still being charged 742 when I have been out of work since last year. And it's based on my income.
It's not really what would be deemed redirect or statement. That's more of a question. And I thought that Ms. Bullis, when she originally gave her testimony, indicated that there had been no additional adjustment because of questions regarding deposits.
Yes.
Okay. And she further indicated that she sent you a request for information about deposits and you just got it yesterday and you and your daughter went through and responded.
I replied.
You reply, and based on the fact that you just replied yesterday, I don't know that a recalculation could have been done sufficiently to adjust the amount of rent that's claimed due and owing, correct, Mr. Hitchcock?
Correct.
Okay. So, and that's why I said, this is Mr. Hitchcock's case and your case. If there's something in your reply yesterday that would affect where we are today, we can pass the matter and you can go and work on it, or the court can take your closing arguments. Your case, not mine. Mr. Hitchcock.
I just didn't, I want to do my closing argument. Obviously, the tenant is always able to provide additional information to try to get a rent adjustment going forward. So this case doesn't bar that from happening if she wants to provide additional information.
Then what we'll do is, Ms. Standifer, I'll have you return to the council table, to the table where you were sitting originally. Mr. Hitchcock will give his closing, you'll give your closing, and we will see what goes from there. And then I see the other attorneys out on the next two cases. Mr. Hitchcock.
Yes. Granted, this is pretty basic, I think. In Exhibit 1, I think that even the defendant agrees that she testifies she's only been paying $300 a month for a few months, and in fact, the rent is $742. And so she's clearly behind in the rent. As Mrs. Bullis has testified, In this particular case, and I provided you the exhibits, there are tons of transactions going on in these accounts. And they show income coming into the account, deposits into these accounts every month. And we've been able to get what I would call a straight story on sorting this out. And under the HUD regulations, we're required to keep the rent at the last certified rent amount until such time as we can certify under those regulations that it should be a different rent, either up or down. There's so many accounts here. I've looked at the answers and responses that have gone on in this. I can't make heads and tails of it either, trying to explain why there's all this movement of money and which money is original new income coming in as opposed to income being moved from one account to another. I would suggest that Mrs. Stanford maybe unintentionally made this a problem or intentionally made this a problem. I don't really know. I can't say that, address that, but it certainly is a problem. And our obligation with HUD is that we maintain the rents, and if she pays this money to us and she can provide the evidence that allows us to adjust her rent, we can adjust the rent retroactively. You know, and we will if she could provide the documentation, or if going forward, if she wants to now say, well, forget about this past stuff, but I can say from March of this year forward, I've got less income, and here's the proof of that, then it could be reduced going forward, if that's a possibility. But our obligation on rules is that we obviously, we can't risk also having a problem of having an audit from HUD where they're after us in our funding that they provide. If it wasn't for the HUD funding, none of these 101 units would exist. So I would ask that you provide us with a judgment for the
Yes, baby.
total amount owing, and if I'm willing to work with Mrs. Stanifer, if she needs some time to make payments on the arrearage amount, and if she just starts paying the 742 now going forward, until such time as we can get any rent adjustment based on accurate information. But at this point in time, I think the client is entitled to a judgment in the amount of $3,342 that are due at this time under her lease.
Thank you, sir. Ms. Sandifer.
So I'm not providing, I don't know what else to do besides give this explanation. Like I said, these are the explanations for where the deposits come from. Every single last deposit in my account. And then there's the deposit because I had to do self-certification for HUD on like 30 pieces of paper. So I don't understand why they're saying they don't know where it came from. And then also on my bank statements, it says in the bottom of the bank statements, deposit from transfer from this account to that account. It'll say Tequila Standiford, Tequila Johnson. So it's not like it's a question to where the income is coming from. It says exactly where it's coming from. But what I was told is that they don't look at, anything else like the transfers. They just look at deposits. But I can't hide this on my bank statement. I can't hide where it came from. And I put everything on here. They gave me all of these sheets and they asked me for every single one. And there's a reply for every single one. So I'm not getting where's the lost information at. I cannot pay 742 if I have not been to work. I can't. If I don't have any money at all, I cannot pay 742. I was paying what I was told, so that's why I put it forth. Now I don't have any money. But I can apply for another SCR if they will give me the proper documentation and allow me to do that with the state. They can help me with some of that. And also, I can look at whatever email she said she didn't get a reply to, but I replied every single one. And I know I will reply every single one And I said 25 back.
Anything else, ma'am? Anything else, Mr. Hitchcock?
Nothing further.
Thank you. The court has had the opportunity to hear the testimony of the witnesses this afternoon and review the documents presented. Of note is that the only household information that shows the rental rate is the document signed by the parties back on March the 5th, 2022, setting the rental rate at $742 per month. Plaintiff additionally has provided a ledger that shows the payments from, the charges and payments from October 2022 forward, ending in a balance of $3,324. The defendant has not produced any documentation that shows that the rental rate should be anything different or the balance is anything different. For that reason, judgment will enter in favor of plaintiff and against defendant with rent due to the plaintiff of $3,324. The court shows a filing fee of $55. Mr. Hitchcock, you're also entitled to your service fee and your statutory attorney fee.
So I would ask for $94, which is really the filing fee and the service.
Plus the statutory attorney fee, and the plaintiff may submit that judgment to the civil department for entry before you leave today, or email it into the court, and the civil department will get it upstairs. Ms. Sandifer, Mr. Hitchcock has indicated that if you provide the documentation or respond to the request for clarification of deposits, that the matter of your rental rate could be addressed or readdressed and adjusted, given the fact that you are out of work and have been out of work because of your issues that arose back in August of 2022. Anything else, Mr. Hitchcock?
Nothing further, thank you.
Anything else, Ms. Standifer?
I just want to be sure, as long as I've given the explanation for the emails and they get the information, they will recalculate or do whatever they do, and they'll give me something else, or then I'll pay that from there. Is that how it's gonna work?
That's how the recertification works, correct, Ms. Bullis?
Yes, Your Honor.
But until you have something in writing, it's not what she says and it's not what Bianca says, it's what's in writing signed by the parties. Anything else? Thank you. That concludes this matter. The file will be downstairs momentarily.
Thank you.
Thank you, sir. Oh, sorry. Oh, jeez. Please tell me they didn't come out the clip. Oh, good. No, sorry, Mr. Hitchcock. That normally I can't reach anything, and then today it just goes careening off. Sir, I'm sorry. I hope not. That never happens. I can't ever even get anything over. I have questions now. We have two left. I know. And it is 2-30179 Sunbeam Property versus Oakley and Robinson.
Judge, we have a resolution.
See, that's my thing. I think if I put you all in breakout rooms long enough, you figure out how to resolve these cases. And what is that resolution, please?
Well, Judge, should we wait for Kiana? I'm not.
She's here.
Oh, can you hear me, Kiana?
Oh, I'm sorry.
Oh.
Ms. Franulik? Mr. Ingram and Mr. George, do you have a resolution or are we having a hearing this afternoon?
Good afternoon, Your Honor. At this point, it does not appear that the defendant is going to be showing up, so no, we do not have a resolution, and my understanding is that Mr. George is not technically representing the defendant.
That's correct, Your Honor. He had reached out to Lakeshore,
Can I-
but I was not able to, sorry.
Can I call the case? I just asked basically where you're ready because we didn't have the plaintiff's attorney on the other case. This is 230-660T. I'm sorry, ma'am. Give me a moment. This is Huron Estates versus James Quillen.
For the record, Brent Ingram on behalf of the plaintiff PH 0491.
George from Lakeshore Legal Aid. I'm just here as an observer today.
Thank you. This case was scheduled at 2:30 for a hearing and a non-payment of rent summary proceeding. Mr. Quillen has failed to appear this afternoon. Mr. Ingram, how are we proceeding?
Your Honor, we would move for a default judgment to enter. Currently, the rent to retain is $3,985.24. Court cost is $164.20, leaving a total redemptive amount of $4,149.44. And the writ date would be 4/17/2023.
Thank you. This case having been scheduled at 2:30, it now being 3:11 by the court's clock, defendant having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $3,985.24, $164.20, and court costs for a total judgment to plaintiff of $4,149.44. Writ date of April the 17th. Plaintiff's office shall submit that judgment to the civil department by email for entry. Anything else this afternoon, Mr. Ingram?
At this time, Your Honor, thank you.
Thank you so very much. Thank you both for your patience this afternoon. Have a good day.
Understood. You as well, Judge.
Thank you.
This is a recall of, I've turned into the Mary Ann. This is a recall of 2300179 LT Sunbeam Property versus Oakley and Robinson.
Oh, wait, on brother counsel now.
You are killing me.
There he.
Sorry, Kiara. Oh, gosh.
It's hump day. It's hump day. That's what it is. I'm certain that that's what it is. So,
Mr. Robinson came at one point and said that you had a resolution of this matter. Is that correct, Ms. Franulik?
that is correct, Your Honor. And to just place on the record, Attorney Kiana Franulik, P73015, on behalf of Sunbeam Property Management.
Steve Robinson on behalf of defendant.
What is the agreement, please?
Your Honor, we have agreed to a conditional dismissal in this matter. The outstanding rent is being, outstanding funds will be reduced to a dollar amount of $8,300 payable by April 28th. And that Oakley and Robinson will vacate the premises by the end of the month.
Is that accurate, Mr. Robinson?
It is, Judge.
And how long will it take the parties to execute and submit the conditional dismissal to the civil department?
About 30 minutes for about 15, 20 minutes for me to get it to Mr. Robinson. And then as soon as I get it back, definitely before the end of the day.
What I will do is adjourn out, indicate in the file that this matter is adjourned for 14 days. I don't expect to see you, but I need to put a control date in because attorneys say they'll get it in and then I don't see it and then Sandy brings it back up. We'll adjourn the trial to 4/19/2023 at 2 p.m. Please get the conditional dismissal in before that date. I have other stuff. I don't want to see you all as nice and pleasant as you've been this afternoon. 4/19 at 2 p.m. back on Zoom, but I prefer the conditional dismissal.
Thank you, Judge. Kira, I'm actually leaving right now. So if I don't, depending on traffic, because I don't text and drive, it may not be for a little bit, so.
Well, that's fine. And it's Kiana, Steve.
Sorry, Kiana.
It's okay.
Anything else on behalf of the plaintiff?
Nothing further, Your Honor. Thank you.
Anything else on behalf of the defendants?
No, Judge. Thank you.
That concludes this matter. You both have a wonderful afternoon.
You too.
Thank you. Everyone have a good Easter holiday.
You too.